To address the overcharging, detention and over custody that had existed both under the Juvenile Delinquents Act and the Young Offenders Act, there are again very specific provisions that were provided in the Youth Criminal Justice Act to address that. One of the first, and I guess would be preliminary within any process, is the allowance for a caution. And in fact, police and crowns are mandated to consider cautioning a young person as opposed to charging them and bringing them before the court. That referral with a caution might be to a community agency and is as an alternative to charging. I would have to say that it's subject to discretion, and so it's had mixed application across the country. In British Columbia, the Crown is charged with looking at each case and determining whether a charge should be laid before the charge is laid, which is really unique and very important. It is true that police and crowns throughout the country do exercise that discretion, but in a human system, when discretion is exercised, unfortunately, issues of perhaps racism arise. And so more children and youth from racialized communities end up before the court. And that's a tragic reality and is something that's being addressed and hopefully will continue to be addressed in our country. It's a blight on the system, but I have hope that it will be remedied. Diversion is mandated. The Crown is mandated to consider diversion, again, if a charge is laid, whether the matter might be diverted to community agency for perhaps some community service, reparation of harm to the victim, perhaps attending at a particular program, for instance, shoplifting. And on completion of that program, the matter brought back before the court and the charge withdrawn, or perhaps there's something known as a stay of proceedings. Stay of proceedings means that there's a notation kept for a year, and if there's no further involvement in the criminal justice system, the charge is essentially noted as withdrawn. That's a formal process. There's also informal diversion that takes place with defense counsel, knowledgeable of the system. They may recognize that the young person is charged, but the nature of the charge or the statement of the charge really overrepresents what happened. And they may see their client as being very pro-social and engage their client in a number of activities, programs, as the young person's processed in the system, and then bring that to the attention of the Crown or at what is known as a judicial pretrial to the attention of a judge with the request that diversion be considered. And that's very often used for nonviolent offenses. Should they continue in the system, that is fraud primarily, perhaps break and enter, and very successfully. So it's both formal and informal diversion is available. Restorative justice is one of the possibilities for diversion. And at the court that we were at, 311 Jarvis Street, the service that was provided to us was done through an organization called Peacebuilders, based on the Maori and New Zealand Indigenous model, engaging the individual and support persons for that individual in a number of meetings to investigate and to discuss the behavior that resulted in the charge, to allow for an understanding of how they may be received by the victim, and the victim equally given supports and meetings with the victim. The victim asked, and only on consent, if they wish to continue with the process and actually eventually meet with the perpetrator in a circle where their safety and security will be protected. I can give you an example. Came to my attention at a judicial pretrial. I mentioned pretrials. Well, in the process of criminal prosecution, the Crown is obliged to provide disclosure, which essentially is all of the evidence that they're aware of that might be led at trial against the young person in this case. And when that's been received by the young person and their defense counsel, they review it and then they meet with the Crown to see if there's some resolution possible. At that stage, if the Crown and the defense counsel feel it would be there'd be merit to bring the matter before a judge to get perspective from a judge as to what they think might eventuate given the information that's available, both the Crown's information and now the defense information in terms of who this young person is, how it might be that they ended up in the situation where they were engaged in criminal activity, with, of course, the proviso that at both the Crown pretrial and the judicial pretrial, any discussion will never be admissible at trial. And in fact, when it's in front of a judge, because that judge has now been apprised of information that would be not necessarily admissible at trial, that judge would normally not be the judge who would conduct the trial if the matter goes on to trial. The exception to that is that defense and Crown can agree that they are confident that that particular jurist can disabuse her or his mind of what they've heard in the pretrial discussion and deal with the evidence only at a criminal trial. The example. So, what did I have? I think there's a total of maybe 12, 14 young people before the court. And they were from two, what I refer to as gangs in the inner city. One group, and I think there were, again, I can't remember the exact number, perhaps 5, 6, were of Southeast Asian heritage. The other group, in the same community, living very close to each other, were of African Caribbean heritage. And there had been a great deal of tension between the two groups for some time, and it erupted eventually in a fight. Fortunately, there was no really serious bodily harm occasion, but the charges were assault and assault bodily harm. And they came to this judicial pretrial, and they were trying to figure out what an appropriate sentence was. And initially, the Crown was to make a statement to the community and to those individual groups looking to have a custodial sentence. And that was certainly understandable in the circumstances. It struck me that it might be really of value to try the restorative justice approach. And so I made a referral with the agreement of the Crown and Defense to Peacebuilders. The individuals went off to Peacebuilders. They were dealt separately for a period of months. This is not a get out of jail free card by any means. Going to restorative justice, it's a very complex and intense process. And indeed, I think I was aware that some individuals, having been through the process, even though successful, had indicated that maybe they would have preferred just to plead guilty, have a quick sentence, and not have to engage in identifying what the harm was and acknowledging their full responsibility by way of a restorative justice approach. In any event, meetings with individuals, with their families, with their support groups, in each group separate for a number of months, establishing understanding of the other group's culture, the other group's heritage, the other group's experience of discrimination and racism, and developing the parameters for how a meeting might take place so that the groups could be brought together in a safe, secure manner, each person allowed to speak in a circle, each person respected, so while they're speaking, no one else speaks. The process was completed, and remarkably, there was a real understanding on both sides of the difficulties that each community faced in the majority society that is Canada, and the discrimination that had been experienced by them. Peace was restored. They were able to return within the community without any further recurrence of violence between them. It was really remarkably successful and allowed for me then, of course, to give a non-custodial sentence. And the Crown was supportive of that because, in fact, the harm had been addressed and peace had been restored. A very, very important concept. And Peacebuilders is very active. Prior to COVID, they were doing in the court system some perhaps 60 cases a year. They also were very active in the school system and trying to keep issues of tension and conflict that arose in the school out of the criminal system and addressing it by restorative justice in those milieus to keep them from being charged. And again, extremely successful. I think their success rate is something in the range, it's over 80% in terms of accommodation that doesn't allow for recidivism. Conferences. Conferences are provided for in the legislation, extremely important. They can be initiated by a judge, by a justice of the peace. They can be initiated by defense counsel. They can be initiated by a service provider. Sometimes judges of assistance in order to bring people to the table and direct that they should come into the room. In my experience, I have attended both conferences where I was in attendance and those when I wasn't. And my strong perception is that conferences are probably more successful when the judge is not in the room. Sometimes it's necessary, but as much as a judge I could take off my gown, I could come in business clothes. It doesn't matter. When I walk in the room, I'm a judge, and everybody in the room knows I'm a judge. And so there's a certain environment in that room that is changed once the judge walks out of the room, and I think allows for conferencing to be probably more successful. Those conferences can be held to consider what conditions, I mentioned before, considers what conditions might be helpful for compliance with bail, what conditions might be supportive of rehabilitation and reintegration in terms of non-custodial sentences and custodial sentences, and very important process to support the court. Detention. Again, specifically to address the detaining of young people at the bail stage. It's specified in the legislation that detention can only occur if the offense for which the young person is charged, allows for consideration of a custodial sentence. And I'll get to that in a moment. Only 4 categories that allow for a judge to consider imposing custody. And if the charge is not one of those, doesn't fall within one of those 4 categories, there cannot be detention. There's an admonition for justices of the peace who do most of the bail hearings and certainly the initial bail hearing, to consider conditions that focus on the youth and allow for compliance. And a good example of how that is important. You may have a young person, 15, 16, who is a ward of the state, has been removed from a family, tragically having experienced remarkable neglect, assault, physical violence, very sad. Those young persons are extremely vulnerable and have terrible trauma in their history. For good reason, those young persons don't trust adults. And so when they're removed from their family, which was the only love they really knew, and placed with strangers, it's very common for them to challenge those strangers, to verify to themselves that, of course, they can't be trusted. They don't really care. Nobody's ever cared for them in their life. So they challenge, they threaten, they may exercise some violence. And lo and behold, they're charged. So for many young people in the child welfare system, it's when they enter the child welfare system that they incur their first charge, criminal charge. Days, weeks, months may be involved in trying to find a particular foster home, group home that has a treatment component to address that particular young person and their trauma. And so they're placed there. Again, predictably, within hours, sometimes within days, but certainly probably within the first couple of weeks, there's going to be a challenge. There's going to be a challenge to those adults there, be it a foster parent, be it a group home staff. And sadly, that often translates into the young person being charged. So now they go to the police station. The police have options to release young persons on conditions and knee-jerk reaction. Police officers say, well, the problem happened in that home, so obviously the young person is not going back to that home. There's going to be a condition that they can be released as long as they don't go back to that home. Or that may be the decision made by a justice of the peace at a bail hearing. The problem with that is you have days, weeks, months of very careful consideration of that young person and their needs thrown out the window for one interruption, which was predictable. So there's been an education process to particularly justices of peace and efforts with the police to try and understand that before there's just that automatic reaction that a young person can't go back to that residence that may have been very particularly specialized in terms of their needs, that they consider the possibility of that return with some accommodations made to protect those who may have felt threatened or experienced some violence in that circumstance. And that happens. Now that those issues have been brought to the attention of police and brought to the attention of justices of the peace in communities where that's happened, and that happened in a project we knew as a crossover youth project, those realities have been experienced. Unique provision. In the adult system, if you want to have a review, if you're detained and you want to have a review of that detention, it's a very elaborate process. You have to order affidavits, you have to order the transcript of the original bail hearing, and then you go to a higher court for a review. Not so in the Youth Criminal Justice Act. The initial bail hearing is almost invariably before a justice of the peace. And with 2 days' notice, you can have a brand new bail hearing in front of a judge, a different judicial officer. And it can be tweaking of a plan. The plan may not have been seen as sufficient in the initial bail hearing. A little tweaking of the plan 2-3 days later before a judge, and the young person's released. Again, my experience and that of my colleagues at 311 Jarvis Street, well over 90% of bail reviews were granted, and the young person was released very quickly having been detained originally by a justice of the peace. Very important provision in the legislation. In those cases where a young person is detained, the justice of the peace or the judge has the power and is mandated to consider whether that detention should be in an open facility or a secure facility. Open is essentially a group home setting with a locked door. Young person can't leave without an escort or specific written permission, but that can be granted for school purposes, for counseling purposes. So it's very important for a young person who may be receiving a very particular academic program or particular counseling, that can continue even though they need to be detained until trial. And then, of course, secure custody for those that must be removed from the community. And there are, sadly, individuals who commit very significant violence and must be placed in a 24-hour lockup in secure facilities. Just of interest, one of the things that happened, again, with the Youth Criminal Justice Act coming into effect was that the vast majority of property offenses have now been diverted. And really what the judges are left with under the YCJA are cases of very significant property or fraud, or more commonly, very significant violence, assaultive behavior, aggravated sexual assault, very serious charges. And that's just sad that remains, but a great success of the legislation, that those matters that don't require a great deal of consideration at a judicial level are diverted out of the system. And they're dealt with in ways that are supportive of young people and their reintegration. Restrictions on custody, I indicated I would speak of that. Yes, well, certainly custody is allowable and is available to the court as a sentence for violent offenses, as it should be. Failure to comply with previous sentences can also result in a custodial sentence. A commission of a serious offense, that is in the context of the adult world, that would be an offense that would call for a sentence of 5 years or more, but it has to be coupled with, and a pattern of previous findings of guilt, can also allow for a custodial sentence. And then there's a fourth category that's in 19 years, I had one case, and I'll read it to you. Aggravating circumstances of an offense such that a non-custodial sentence would be inconsistent with the purpose and principles of sentencing. Well, the only case that I dealt with was a young person who assisted, after a murder, a young person who had assisted the perpetrator of the murder to secrete and dispose of the body. Didn't come under the categories because the person didn't have a previous record, but obviously was aggravating to the extent that a custodial sentence was something that should be considered and was imposed. Important principle, even with those four categories. So if presented to a judge and the Crown establishes that the gateway is there, one of the four gates is open in terms of custody, the judge is then required and mandated under the legislation to consider alternatives to custody and state on the record why those alternatives are not sufficient to hold the young person accountable for the seriousness of the offense, their role in the offense, with a non-custodial sentence. So again, very clear admonition to the court, to those that are in the system, that custody should be reserved only for the most serious cases. Custody orders. Well, we don't have 10 years and life imprisonment and that sort of thing as you do in the adult system. Maximum is 2 years. unless it's an offense that would, in the case of an adult, allow for a sentence of life imprisonment. And then it can be 3 years. So that's it. In the youth system, 2 years or 3 years. 3 years being very rare. And a custody sentence is automatically a sentence that has 2/3 of the sentence in custody and 1/3 in community supervision. 9 months, 6 months of custody, 3 months in the community. So a 9-month custody and supervision order, that's what it looks like, 6 and 3. The court again is allowed to stipulate the level of custody, be it open, be it secure, for the reasons that I mentioned before in terms of detention. And important also to consider that if the court determines that custody and supervision should be ordered, and that the young person also should be subject to probation, the total length of the sentence can still only be 2 years, unless it was a case that an adult would be sentenced to life imprisonment, and then it would be 3 years. So any custody, supervision, and probation must be completed within that period of time.